Thank you very much for the billing. I hope I manage, at least in some part, to live up to it. I should say that as was rightly pointed out, the last time I think I stood on my feet in University College Galway, as it then was in 1973. I was then a student in final year in King's Inns, and I was here to take part in an Irish Times University debating competition. And over lunch we were discussing that matter, and one of the reflections I had was that of the finalists that year, that was an early round, which we obviously got through and got to the final and were runners-up. But I think almost half the people who competed in the final that year ended up as judges. So maybe there's a moral in that somewhere, irrespective of whether they were law students or otherwise at the time. The topic of today's seminar is on the question of reform of the courts. And it's perhaps appropriate to start by reflecting that the 100th anniversary of the establishment of independent Irish courts is fast approaching. Whether one views the beginning of the court system in an independent Ireland as being found in the Constitution of the Irish Free State in 1922, or in the Courts Act of 1924, which put flesh and bones on the structure envisaged in the Free State Constitution, we are fast approaching the centenary. And it seems to me that that makes this a most appropriate time to review our court system, to reflect on what might be felt to have worked well, but also to consider that which may need to be changed. In passing, I think it is worth reflecting that those two categories are not necessarily mutually exclusive. Structures, practices, procedures which may have worked well enough in the past may be unable to cope with modern conditions. The world of litigation, whether criminal or civil, is, I think, very different from that which I first experienced as a young barrister being called to the bar in 1973 and thereafter. And I think we should therefore be prepared to recognise that the mere fact that things may well have served us reasonably well in the past does not necessarily mean that they may not require to be adjusted to serve us equally well in the future. That being said, I think it's also of considerable importance to resist the temptation to introduce change just for change's sake. Against that backdrop, it should of course be said that the concept of reform of the courts is potentially extremely broad. Indeed, I was interested to hear Professor Mullally indicate that he hadn't any great overlap in his observations, which he had written without reference to my paper, to the matters that are referred to in mine. It's a very broad church. It could encompass, for example, issues such as the recruitment and appointment of judges, together with disciplinary issues. But I think the position of the judiciary on those questions is now well known, and as the time is limited, I would propose to concentrate on other questions. Principally, I hope to make some comments on the structure of our courts, both in the criminal and civil jurisdictions, and also to address issues concerning how the court process might be improved, together with addressing the resources which would be necessary to allow innovative procedures to be adopted. However, before going on to consider those questions, I'd like to touch briefly on the question of judicial training and the somewhat connected question of the collation and dissemination of information about the courts. I know that the Judicial Council Bill makes provision both for judicial training and for the collation of sentencing information to become part of the functions of the proposed Judicial Council. And in my view, both of those measures form a particularly important part of the remit of that council. I think it's particularly important that that body not be seen simply as a disciplinary body, but rather that it should be seen as a body designed to enhance judicial standards through a range of measures, including, importantly, training and the collation and provision of useful information to judges to assist them in the exercise of their judicial role. As many will be aware, the court service suffered a particularly severe cut to its financial allocation during the years of the Great Recession. Frankly, for reasons which I have never fully understood, the reduction in the allocation to the court service was significantly greater than the average reduction which occurred across the board throughout the public sector, but was also significantly greater in comparison with the reductions to other parts of the justice sector, such as the Gardaí, the prisons and the like. But be that as it may, and whatever may be the reason for that, the particularly severe cuts encountered by the court service made it virtually impossible to introduce any new programmes, and indeed existing measures were by and large only maintained, if at all, with very considerable difficulty. And against that background, I think it's hardly surprising that both the existing judicial training programme and the sort of IT systems that are needed to collate information about what happens in the courts were left very much in their pre-recession state, and it was difficult enough even to achieve that level of maintenance. The overall budget, for example, for judicial training comes to just a little over €300,000 per annum. In a report prepared by the University of Limerick about perhaps 10 years ago for my predecessor but one, Chief Justice John Murray, it was estimated at that time that a proper judicial training programme would require a budget of about 4 times that amount. And many Irish judges, myself included, have had the great benefit of being sent on judicial skills training courses to Scotland soon after our appointment as judges. It was in truth a source of some embarrassment that Scotland, a jurisdiction which is broadly of our own size and with similar financial resources, had a much more sophisticated system of training than anything we could offer, thus requiring Irish judges to obtain much of their training abroad. At present, the question of judicial training is covered by the Committee for Judicial Studies, which operates under the auspices of the Court Service. In the light of the fact that the financial situation is beginning to improve, that committee at its most recent meeting decided to review the University of Limerick report and to update it, taking into account recent developments. And what is envisaged is that the committee would develop a revised blueprint for a proper judicial training regime, which would comply with best international practice, such as those set out in the Handbook on Judicial Training Methodology in Europe, produced by the European Judicial Training Network. It would then be my intention to open discussions with the Minister for Justice and Equality about the funding requirement needed to implement those measures, likely over a number of years. Obviously, if and when the legislation providing for the Judicial Council is both enacted and comes into full practical effect, then such programme can easily be taken under the wings of the Judicial Council. But it seems to me that we shouldn't wait for the Council to be fully up and running to start the planning and, if necessary, depending on timing, the implementation process required to put in place a modern, fit-for-purpose judicial training scheme commensurate with that which applies in almost all other developed countries. In like vein, it was virtually impossible, due to the particularly severe cutbacks that were applied in the IT sector within the court service, to develop any new forms of information systems which might help give guidance to judges in matters such as sentencing. Again, with the reversal of at least some of the financial cuts, plans are afoot to consider how best to correlate and make available to judges information about what happens in the courts in a way that would, I hope, be useful both to judges but also to those who might wish to carry out academic research. Those two measures, that is, a plan for enhanced judicial training and that for enhanced information, will form part of a general proposal which it is hoped may go to government during the next budgetary round. The intent would be to seek to persuade government of the benefits of increased funding to allow for specific measures to be introduced. I have to say that I have long believed that a request for more funding by itself is most unlikely to ever receive a favourable response, unless it is coupled with an evidence-based case for the benefits that are likely to flow from that funding. And I think the same applies to all aspects of reform of the courts. But against that general backdrop, it might be appropriate to start with some general observations before addressing the questions of court structure, procedure and resources in more detail. Significant change in the way in which courts operate should not be ruled out, but it does require careful consideration. The risk of unintended and often adverse consequences is significant. Some measures have in the past been introduced, often with limited consultation with the practicing professions and the judiciary, which have turned out to be counterproductive. At this stage, perhaps just one example, and it's by no means the only one, might be appropriate. There's an often expressed concern about the fact that legal proceedings can hold up important development projects. Indeed, we've had such concerns expressed about the project not a million miles away from here in the very recent past. And from time to time, changes in the court system have been introduced with the stated purpose of remedying that perceived problem. For example, a new requirement was introduced by statute, which required any party seeking leave to bring judicial review proceedings in a wide range of environmental type cases to put any affected parties on notice of the application for leave, and at the same time the standard or the threshold which had to be met in order for leave to be granted was changed from the traditional one to one of substantial grounds, and the requirement to have standing to bring such proceedings was changed to one where the intending challenger had to show a substantial interest. The well-intentioned purpose behind those measures was to seek to remove unmeritorious claims from the system at an early stage while allowing significant cases to go to full hearing. However, the practical consequences were very different. The application for leave itself then became a major hearing because challengers were entitled to be heard properly in circumstances where their case might be terminated at that stage by refusal of leave. There also were lengthy debates about the precise application of the new standards of substantial grounds and substantial interest. It took quite some time for the jurisprudence to become well established, and during that time, those issues potentially were contentious in very many cases, perhaps almost all cases. While there has not been any very detailed research into the question, it is, I think, fair to say that the universal view of both judges and practitioners in the area was that the measures introduced had the net effect of making relevant litigation more rather than less complex, and therefore lengthier rather than shorter. For example, in a not insignificant number of cases, there ended up being 2 significant hearings at first instance in the High Court, dealing respectively with the application for leave and the substantive application after leave was given. This led to judges introducing an innovation of the so-called telescoped hearing in an attempt to solve the problem which the legislation had created. As I mentioned, many other examples could be given from other areas of practice, but the overall point is that there is a significant danger in superficially attractive knee-jerk reactions to specific problems. But I would like strongly to emphasize that this is not an argument against reform or change, but rather an argument against sufficiently worked out reform. A second general observation might be that we have adopted an overly piecemeal approach to reform within the courts over the years. Particular problems were identified. Potential solutions were suggested. To a greater or lesser extent, those solutions may well work. But there has been limited overall consideration to the structure and practices of the courts as a whole. Third, it's not possible, in my view, to distance issues concerning reform from issues relating to resources. Late last year, I was asked to address some comments at the beginning of the new legal year, and I noted in that address that successful reform almost invariably requires both a better use of existing resources and the deployment of additional resources. I've spoken elsewhere about the fact that Ireland has the lowest number of judges per head of population in the developed world, bar none, and that the backup resources provided to Irish judges is at a minimum at the lowest end of the scale when any measure of national wealth is taken into account. I have acknowledged that comparisons in this area can be difficult. It's clear, for example, that the resources required to operate a court system in the civil law world are significantly greater than those needed in common law jurisdictions, although the saving thereby accruing to the taxpayer in a common law country such as Ireland is normally at the price of transferring significant costs to litigants who do not have the benefit of state support. However, even making allowances for that important distinction, I feel that it must be made clear that we cannot expect a first-class court system by allocating significantly less finance to it than other comparable countries. What I would glean from those general observations is that we need a holistic approach to court reform, which acknowledges that all of the pieces need properly to fit together. They need to be properly resourced, and they need to be carefully designed. But that being said, I think it is wise to make one further acknowledgement before going on to consider the major elements of reform which might need to be approached in that way. In situations such as this, it is often said that the best is the enemy of the good. In trying to design the perfect system, we spend so much time and have so much debate that reasonable reforms are postponed. Likewise, there is often a problem with what I think can be best explained by reference to the old joke of the American tourist who, on being asked for directions in rural Ireland, heard the reply, "Well, if it's to there I was going, sir, it's not from here I'd be starting." It would be naive to think that things can just be changed without paying some attention, at least, to where things are now, how they have developed to this point, and the challenges that will be encountered in bringing about that change. But that does not mean that we should not attempt to set out the destination which we would like to reach and how we might like to get there. And in so doing, we should also acknowledge that it is almost inevitable that any new system will require some tweaking when it begins to operate in practice. And indeed, if I might divert for a moment to what we've been doing in the Supreme Court, as many of you may know, the Court of Appeal came into existence just over 3 years ago. That led to the Supreme Court having quite a significantly different role than had hitherto been the case, with the Supreme Court now only hearing a relatively small number of important cases. New procedures were put in place at that time, which I think in the round have worked reasonably well, but the Court acknowledged that trying out any new set of procedures is inevitably going to lead to some problems, and we are currently engaged in a review of the procedures that were put in place, and there will undoubtedly be some tweaking of those procedures. It shouldn't be taken as an admission that you got it wrong in the first place, that you have to revisit something after 2 or 3 years to improve it, and I think we need to be brave enough to make that acknowledgement. What I would propose, therefore, is that we seek to instigate a debate among all interested parties, being the judiciary, the practicing professions, the legal academic community, government and all other stakeholders within the court system, whose aim should be to produce a high-level blueprint of the kind of court system we would like to see in place on the centenary of the creation of the independent Irish courts. I think there's enough time to do that within that time frame. In that context, there may well be room for legitimate disagreement. There will undoubtedly be resources issues. The process of implementation may well, as experience has shown, take longer than anticipated. But at least if we have a well worked out idea of what we want, then we have a much better chance of having buy-in to any of the changes proposed and of ensuring that significant unintended consequences will be kept to a minimum. I don't believe that there are any magic bullets. There's no one big idea which is likely to provide a court system with which everyone will be entirely happy. But in order to launch a debate of the type I propose, it seems to me that it might be useful to at least identify the principal areas which may need to be considered. I would, however, emphasise that what I would see each of these areas, that I would see each of these areas forming part of an overall approach, although obviously issues of detail may need to be considered in each of the areas. Indeed, quite frequently, the devil in such matters is truly in the detail. So I turn first to the structure of the courts. Because in a very real sense, this question lies at the top of the court's food chain, I should start by making clear that I'm not necessarily suggesting that our structure needs significant change or reform. However, I think the time is appropriate to at least consider whether a structure which has broadly served us well in the past continues to be ideal for the demands of the courts into the second centenary of Irish independence. With the exception of the recently established Court of Appeal, which I've just mentioned, the basic structure of the courts in Ireland has remained more or less the same since independence. Indeed, with the exception of the creation of a district court presided over by professionally qualified judges to replace the previous magistrates' court, and some other minor changes, the model which has been in place since independence was, in effect, present for much of the latter years under British rule. The Constitution envisages courts of local and limited jurisdiction. Historically, there have been two, the District Court and the Circuit Court. Our model of courts, therefore, which establishes three different layers of first instance trial courts, the District Court, the Circuit Court, and also the High Court, with typically one appeal being available normally to the court immediately above the court from which the appeal is brought, is actually quite unusual by international standards, particularly in civil law countries. But it is similar to the model which operates in the United Kingdom and its various constituent parts, largely because we inherited it from that source. There are also other features of that system which perhaps are worth considering. The jurisdiction of the Circuit Court and the District Court is conferred on a specific circuit or district. Judges of those courts can be permanently appointed to be the judge of a particular circuit or a particular district. While it is true that both courts have now a significant number of unassigned or movable judges who can be deployed to assist as required, it remains the case that the fundamental structure of the Circuit and District Court is based on the theory of there being, in almost all areas apart from Dublin and Cork, one single assigned judge who is at least theoretically responsible for all of the business coming before that court in the relevant circuit or district. I think it is fair to say that that system has worked well in the past. However, it is worth at least examining whether it is an ideal system to bring us into the future. One of the problems can concern jurisdiction. Questions can arise as to whether a case has been properly brought in the right area. Questions about the jurisdiction of assigned judges can also arise. A further interesting question was brought clearly to my mind in recent discussions which I had with one significant regulatory agency. Those discussions took place as part of an attempt on my part to learn the views of major users of the courts about how the courts are operating. And that agency brought to my attention the fact that in the Dublin Metropolitan District of the District Court, there is now a so-called regulatory court, where a single judge deals with all regulatory cases, thus allowing for the development of expertise and making consistency much more likely. Illegal dumping kind of cases, a whole range of different types of regulatory proceedings are now in place. But that's only possible because the volume of cases in the Dublin area is such and that the president of the district court can assign a single judge to deal with a specialist area. The full-time children's court in Dublin is another obvious example, but many more could be cited. Thus, it is possible to arrange the business of a large area such as the Dublin Metropolitan District in that way because of its scale, so that judges spend at least a reasonable period of time doing the same kind of work, which contributes to expertise and to consistency. It's an awful lot more difficult to try and achieve the same type of thing in a district area where there's a single judge who is required to deal with all types of cases that come before them. And indeed, as an aside, the regulatory agency that I was speaking to made the point that because a lot of the entities that they regulate are corporate and a lot of them have their registered offices in Dublin, they often have the option of bringing cases in Dublin where the defendant resides, as it were, even though the events that gave rise to the matters that they are attempting to regulate might have happened elsewhere. And that they do that precisely because they have available in the Dublin District Court a judge who has expertise in that area because of being able to conduct a volume of case in the area concerned. I think similar issues, though perhaps on a lesser scale, can also apply at the level of the Circuit Court. And I think it is worth commenting that we increasingly, in a highly regulated world, create regulatory issues, whether criminal or civil. We frequently want to put them for cost reasons, I suspect, and perhaps also for reasons of locality, into the lower localised courts. But then we expect judges who are meant to deal with everything to have the expertise to be able to deal with those regulatory cases without, in almost all cases, giving them anything remotely like proper training in those areas. And I think, therefore, it is important to emphasise that we do live in an increasingly complex and more regulated society. And new legislation does place a significant burden on the courts, and that kind of legislation is very frequently introduced using the lower courts as the means of enforcement. In such a world, I think it is at least open to question as to whether the model which has been followed to date is really ideal for the future. However, going back to the first general principle which I sought to identify, it would be wrong to conclude that the case for a change is made out. But rather, I strongly think that there is a need to carry out a broad assessment of whether the overall structure of our courts of first instance are ideal for the challenges which the court system is likely to face in the future. Perhaps the conclusion of such an assessment might be that the present system, with or without minor tweaks, remains the best. But I think, at a minimum, we need to ask the question and invite a broad debate as to the answer. Before leaving this question, there are a few further points that are worth introducing. The first is the rather curious system whereby the appointment of a judge of the district or circuit court to a particular district or circuit number X covering Galway, or circuit number X being the Western Circuit, or district court X involving Galway, is both permanent, meaning that the judge concerned cannot be moved without their consent and thus may serve in the same area for a very lengthy period until retirement, and is made by the government rather than by the president of the relevant court. It's a surprising feature of our structure of courts that the president of the High Court exercises a much greater role over the allocation and management of judges in respect of particular types of cases than does either the president of the Circuit Court or the District Court. Second, it's also necessary to take into account the fact that all of those courts exercise both civil and criminal jurisdiction. While there is not necessarily a great deal of difference between the way in which a civil case is conducted, whether the case is commenced in the district or the circuit court, there is, of course, a very significant difference on the criminal side. The principal criminal jurisdiction of the circuit court is to conduct indictment trials, where questions of guilt or innocence are determined by a jury. The principal criminal business of the district court is to conduct summary trials, where the district judge determines guilt or innocence, as well as imposing sentence when appropriate. That important distinction is rooted in the constitutional requirement that a person be entitled to trial by jury in the vast majority of cases, excluding special or military courts and so-called minor offence cases, which are allowed to be tried summarily and thus in the district court. That may provide a continuing rationale for two separate courts, although even that does not necessarily follow, because it would be possible to have a single court which could operate trials in different ways, and whereas in the UK the conduct of more difficult or complex cases are assigned to judges of greater experience in the area. Again, I don't want to be prescriptive as to the outcome of any debate, but would emphasise that this is a debate which I think we should now have. One final aspect of that structure which perhaps would merit attention is the system of appeals. In an address which I gave recently to the Law Reform Commission, I drew attention to the fact that there is an unnecessarily complex system of appeals in place, both within the courts and where the courts are given the statutory jurisdiction to hear appeals from outside bodies. I suggested to the Law Reform Commission, and I repeat that suggestion here, that this is an area which would merit significant streamlining. As I pointed out on that occasion, it's frequently the case that a significant amount of court time is taken up on debates about whether the right appellate or review procedure has been followed, rather than the merits of the case which is to be made on the hearing itself. For example, there are regular issues about whether an appeal as opposed to judicial review is the most appropriate means of advancing a complaint about a first instance hearing. But even within the courts, there are a range of different types of appeal or review procedures which potentially make the structure of second instance hearings unnecessarily complex and unwieldy. I would suggest, therefore, that any review of the structure of the courts should pay particular attention to the means whereby first instance decisions can be reviewed or appealed. In the same context, as I also recommended in my address to the Law Reform Commission, some rationalisation of the very many different ways in which statutory appeals from various tribunals or other decision makers are channelled into the court system is a further area of complexity which would merit review. Before leaving the question of appeals, it seems to me that there's one further issue which should be addressed. In most cases, our appellate structure within the courts involves an appeal to the court, as I mentioned earlier, which is immediately above the first instance court. The one exception to that general rule arises in the case of criminal trials conducted in the Circuit Court, where the appeal is brought directly to the Court of Appeal rather than the High Court, which would be the court next up in the hierarchy. That would be the case in a civil appeal from the Circuit Court, which does go to the High Court. However, that's perhaps an idiosyncrasy that doesn't make a great deal of difference. More importantly, certain appeals involve a complete rehearing of the case. This applies in respect of civil appeals from the District Court to the Circuit Court and civil appeals from the Circuit Court to the High Court. It also applies in the case of criminal appeals against summary criminal convictions or sentences imposed in the District Court. However, all other appeals, at the higher end of the scale, I suppose one might say, including criminal appeals from the Circuit Court, are based on the record of the trial. It's easy, I think, to understand how in an age when the then equivalent of our now District Court involved lay magistrates, that it might have been considered that a complete rehearing was the appropriate means of reviewing a first instance decision. However, it's at least open to question as to whether that continues to be the case today. I would suggest that it's at least worth considering whether our system should continue to contemplate cases which are completely reheard on appeal. However, as in many other areas which I will consider in the course of this address, there can be resources issues involved in deciding whether to move to a universal system of appeal on the record. The public, I suspect, might be very surprised to learn that historically, very limited formal records have been kept of the evidence in a great number of types of court cases. Indictment criminal trials are an exception, as are a relatively small number of civil cases where the state provides for a formal transcript. However, in virtually all other cases, any party wishing to have a formal transcript is required to make and pay for the arrangements themselves. Clearly, an appeal on the record can only make sense if there is a proper record in the first place of the evidence, including all documentary exhibits introduced. Now, we do now, of course, have a digital audio recording system which applies in almost all courts and can allow for a transcript to be produced if needed. However, there would undoubtedly be significant cost implications if the court administration were required to be in a position to provide a full record of every trial in every court. On the other hand, it might well be considered necessary in modern conditions that such a record exist in any event. But be all that as it may, I think there is at least a strong case for the proposition that the conduct of trials without a complete record should become a thing of the past. And if that becomes so, then there is at least a case to be made that our appellate structure within the courts should move to one where appeals are conducted on the record rather than a complete rehearing. However, the overall structure of the courts themselves is not the only issue involved in court reform. What happens in the conduct of court proceedings, both civil and criminal, from the time that the proceedings are commenced to the time when a final judgment is given, in my view, merits a broad-based review. It might again be useful to start with one very general observation. Our court system, like others in the common law world, places very great emphasis on the conduct of a single trial or hearing which is designed to determine all issues in the case. The whole procedural edifice is built around building up to the trial, which decides everything. It's not necessarily the case that this is the best or the only way in which litigation can be conducted. It is sometimes suggested that deciding issues which arise in a logical sequence might save a lot of court time and expense for the parties. For example, a case may throw up a range of issues, but some of them may fall away depending on how earlier issues are decided. The classic example would be, I suppose, to leave over the question of the assessment of damages on the basis that it may not arise unless and until there's a finding of wrongdoing on the part of the defendant. It's true that in comparison in criminal cases, we do not go on to consider issues concerning sentence unless and until a conviction is recorded. Obviously, in cases being tried before a jury, there would be very strong reasons in principle why evidence relevant only to the which is relevant only to the appropriate sentence should not be presented at the trial. But even in cases where a judge, such as a judge of the district court dealing with a summary case, will decide both conviction and, if there is a conviction, on sentence, it would never be suggested that it would be appropriate to tender evidence relevant only to sentence before the judge had decided to convict. In civil proceedings, however, it's commonplace that all of the evidence relevant to all issues is presented at a single trial, even though it may turn out that some issues don't have to be addressed because of decisions made in relation to other questions. On the other hand, I think it has very frequently been noted by trial judges that the longest way round is often the shortest way home. Attempts to segmentalise hearings by means of, for example, trial of preliminary issues, or what has come to be known as modular hearings, have frequently led to the proceedings becoming more rather than less complicated. That is not to say that there may not be a place in appropriate circumstances for such an approach. For example, in complex litigation, it's often the case that questions of damages are left over until after liability has been established, most particularly if the question of damages would itself be complicated, requiring significant evidence directed to that end and assessment by the judge. Perhaps more work needs to be done in attempting to map out the circumstances in which it does make sense to move away from the default model of a single major trial of all issues in civil proceedings. But that being said, my own suspicion is that such a model, or at least a close variation on it, will remain the centre of our proceedings into the future. But what flows from that? Well, it seems to me that it follows that the procedures required to be adopted must remain designed to ensuring that that single trial is conducted in a fair way, without unfair surprises, and without having to be interrupted because new materials or new arguments are introduced to the surprise and prejudice of an opposing party. But whether our process as it has evolved is now properly fit for that purpose is, in my view, open to significant doubt. Furthermore, the trial itself and the manner of its conduct is a matter which may warrant further consideration. The trial is often one of the most expensive parts of the court process. The longer it takes, the more costly it's likely to be for the parties, and the more it will undoubtedly use up scarce court time resources. But equally, it is essential that any reforms do not compromise the ultimate task of the trial, which is to deliver a just and fair result in accordance with law and on the basis of the evidence. At a big picture level, therefore, the object of the court process must first be to devise pretrial procedures which do not, in and of themselves, unnecessarily complicate matters and add to cost, but which at the same time ensure that all reasonable steps are put in place to deliver that form of fair and just trial which I've sought to identify. And in addition, the trial process itself must be such that it too delivers that stated object. Many of the questions which thus arise are likely to be the subject of the committee established under the President of the High Court, Mr. Justice Peter Kelly, to conduct a thorough review of civil procedure. The issues are ones where, in very real terms, the devil is in the detail, and that detail requires careful and balanced consideration, and I wouldn't wish in any way to preempt the findings of the Kelly Committee. However, it does seem to me that a number of general areas can be identified which would warrant particular attention, and I would propose, at least briefly, to identify and comment on these. So far as pretrial civil procedure is concerned, it's fair to say that it can reasonably be divided into two parts. The initial phase involves the pleading of the case. The theory is that the issues, both of fact and law, which arise in the case should become clear as a result of the filing by the parties of the relevant pleading documents, together with the process available in all first instance courts to obtain greater detail of any claim or defence. However, I think it's fair to say that the pleading process has become extremely formulaic, often sheds little light on the true issues that are likely to arise at the trial. Indeed, it's likely that the limited utility of pleadings in their current form was one of the reasons which lay behind the move in various areas of practice, particularly in the High Court, to require the exchange either of witness statements, as applies in the commercial court and certain other areas, or expert reports, as applies in the personal injury field. I'm mindful of the fact that it would be a mistake to provide for over-elaborate pretrial procedures, which are applicable in all cases. Obviously, the more work that has to be done at an early stage of a case, long before it comes to trial, the more the costs of litigation are front-loaded, and the more the savings to be achieved by early resolution of the case are potentially reduced. On the other hand, it does seem to me that there's a strong case for revisiting the pleading process so as to require a greater engagement on both sides with what their case really is. Such engagement should allow the pre-trial process to move on with a much clearer picture of what the real issues in the case are likely to be. I do accept that one of the problems with the current pleading system is the understandable fear of practitioners who may be concerned that they may be disadvantaged if they don't plead their case as widely as possible. Those acting for plaintiffs may be concerned that they may be shut out from making a potentially winning case at trial because their pleadings are overly narrowly drawn. Those acting for defendants may be equally concerned that they may be taken to have made admissions which they didn't intend to make if the defence is not drafted in a way which denies virtually everything. It has sometimes been suggested that this tendency to plead in the broadest possible terms might be alleviated if courts were to take a more liberal attitude towards allowing amendments to pleadings or even the pursuit at trial of cases which were not fully set out in the pleadings. However, that too brings its own problems. The whole point of the pleading process is to define the parameters of the case, both for the purposes of subsequent pre-trial procedures and for the trial itself. Unless there's some reasonable rigour applied in requiring parties to stick to the case as pleaded, then the pleading process may fail to achieve even that basic function. Again, there's no magic bullet to this problem. However, it seems to me that real consideration should be given to devising a replacement for the current pleading system in which parties are required, by which parties would then be required to set out a full statement of their case, including, where appropriate, reference to the evidence which they intend to introduce in support of the case, and also to require copies of at least the central documentary evidence, if there be such, that they intend to rely on, to be supplied. It would, of course, require particular care to ensure that any such new system did not itself fall into the problem of becoming unduly formulaic. Likewise, I would caution against creating a one-size-fits-all approach, for experience has shown that the detail required to ensure that all sides properly understand the case which they have to meet may vary significantly from type of case to type of case. Perhaps the solution to that problem requires a greater degree of judicial or quasi-judicial scrutiny of the pleading process than has heretofore been the case. And that observation leads neatly to the second area which I would wish to address, which is case management. It's often said that one of the key distinctions between the common law court process and that which applies in civil law jurisdictions is the extent to which the process is party-led in the common law world, but judge-led in civilian countries. The distinction may not always, I think, be quite as black and white as that description suggests, but there can be little doubt but there is significant substance in that distinction. It's worth noting how the current process works in a common law jurisdiction such as Ireland. The parties exchange pleadings, as I've described. If they're not satisfied with the level of detail, and they almost always are not, a so-called notice for particulars is served, which requires further detail of the matters said not to be sufficiently particularised. If a dispute emerges, and not infrequently that is the case, it is the party aggrieved which brings a motion before the court seeking to resolve the dispute. In the absence of any party bringing such a motion, it's important to emphasise that in our system at present, and outside areas such as the commercial court where different rules apply, a judge will in fact have no contact with the case until it becomes ready for trial. Likewise, where parties are slow in complying with their procedural obligations, a judge again exercises no role unless and until a party brings a motion. Indeed, if I might divert for a moment, it has now become the case that the number of those motions that are brought in the High Court leads to extremely lengthy lists before a significant number of judges, which takes up most of the business of the High Court on Mondays. It might be said that quite an amount of that work is entirely routine and could more properly be dealt with by a quasi-judicial court officer, with a reference to a judge only in cases of difficulty. This is a more general question to which I will shortly return. On the other hand, there can be applications, such as those involving the scope of documentary disclosure, which are complicated and very difficult to deal with within the time constraints of a lengthy motion list. It seems to me that many of the motions don't need to be put before a judge at all, but that some of those that do need a lot more time. In any event, the move in more recent times has been towards a greater amount of hands-on judicial case management. Now, I fully support the practice, and my experience as a judge of the commercial court has convinced me that it can often prove significantly beneficial in narrowing down the questions that need truly to be debated at trial, and thus ultimately save costs. However, that being said, I agree with those who suggest that care needs to be exercised so as not to overburden relatively straightforward litigation with what may turn out to be unnecessarily elaborate pretrial procedures. The fact that a very high level of hands-on case management worked well in the commercial court, where litigation tends to be both complex and heavily document-driven, does not mean that precisely the same procedures would produce a net gain in every other type of litigation. However, it's difficult to avoid the conclusion that some form of more active judicial oversight of the pretrial process in all cases is a matter which needs active consideration. The oversight required may be relatively limited in certain types of cases, such as personal injury cases perhaps, but may also require to be significant in those cases which warrant major judicial input at the pre-trial stage. How can we achieve this? That leads to what seems to me to be a vital part of any reform of the pre-trial process. It is the need for increased judicial and quasi-judicial resources. If we are to move from the current situation, where there is no judicial or quasi-judicial involvement in the pre-trial process unless one or other party seeks to invoke the jurisdiction of the court by motion, and excluding those limited category of cases where there is already a high level of case management in any place, then it is inevitable that a significant increase in the resources deployed will be needed. In that context, it's perhaps appropriate to say a little about how the system works today. The public might again be surprised to learn how little a judge assigned to hear a case in very many parts of our system will know about that case in advance. It is perhaps first appropriate to draw attention to the fact that the amount of documentation which the court office holds in respect of a typical case is significantly more limited than the public might suspect. Not all documents by any manner of means require to be filed, Those that are required to be filed are often brought into court at quite a late stage in the process. Whether this is an entirely satisfactory state of affairs is a matter which can be debated, but it does need to be acknowledged that a requirement for a court registry to hold and retain the level of documentation which would typically be held in a civil law jurisdiction would place a very significant additional burden on court offices which could not be met without substantial increase in the scale of their operations. Likewise, a judge assigned to hear, for example, one of the Monday motion lists which I've described, will rarely have the opportunity to see any of the documentation likely to be referred to by the parties in advance of the motion being called on for hearing, and the necessary papers being handed up to the judge by the solicitor acting for the moving party. Likewise, such motions will come before whatever judge may be the assigned to the particular list on that particular Monday. Thus, if a second or subsequent motion in the same case is brought before the court, it will be by no means necessarily heard by the same judge who considered the earlier motion. For all of those reasons, it's extremely unlikely, in most cases, that any judge dealing with any aspect of the pretrial process in most types of civil proceedings will know anything about the case in advance, including knowledge of any previous applications which the court may have considered. The situation may be somewhat different in particular types of cases where, for one reason or another, a specific judge is assigned to handle all of the case management in a particular case, or where the system makes it likely that that will be so in any event. But in such cases, the advantage of the same judge dealing with all pretrial matters only truly arises where that judge is given a reasonable opportunity to become familiar in advance with the management issues likely to arise. For example, a judge dealing with a motion list in the commercial court will not only have to deal with a much smaller number of motions than a judge dealing with a similar list in respect of almost any other area of the High Court, but also that judge will typically be given a reading day in the immediate run-up to the motion list, so as to enable the judge concerned to become familiar with the papers and the issues which are likely to be raised before the court. And I think the moral of that story is that case management only makes sense if judges are given enough time to become familiar with the issues that they are going to have to address and are not faced with having to manage so many cases that they cannot devote sufficient time to each. That proved possible in respect of the commercial court because successive presidents of the High Court have been prepared to assign a sufficient number of judges to enable effective case management to take place. However, given the current level of judicial resources, it would just not be possible to apply the same regime in too many other areas. I say that while acknowledging that the level of management which may be appropriate to the commercial court may not be needed, or at least not needed to anything like the same extent, in other types of cases coming before the courts. However, even the most gentle form of case management requires not only that a judge be available to conduct the case management hearing, but that the judge concerned can go into that hearing with the sufficient knowledge of the case so as to be able to make an effective contribution. If, therefore, we are to move to a situation where there is generally to be a much greater level of judicial involvement in the pre-trial process, it will inevitably require more resources. Should those resources become available, then it seems to me to be likely that the revised type of pleading or statement of case which I've advocated could be introduced on a much more effective basis with judicial oversight on the question of whether the process was truly identifying the issues which needed to go to trial. Furthermore, all subsequent aspects of the pre-trial process, such as disclosure of facts or disclosure of documents, could be managed in a much more effective way. While acknowledging that the level of judicial input which would be required may vary significantly from case to case or type of litigation to type of litigation, nonetheless it will not work unless judges are given the time to be able to deal with the issues arising in an effective way. It is important to emphasise in that context that time means not just time sitting in court, but time reading into the issues in advance so as to reduce the amount of costly court time taken up. And furthermore, it may, in a limited number of complex cases, also require time to reflect on the proper course of action to adopt, and in some cases to deliver a written judgment on issues arising. But as I've already indicated, it seems to me that not all of this work needs necessarily be done by judges. I have often commented on the fact that the High Court of Northern Ireland, which has 10 judges, has 6 quasi-official officers called masters. Our High Court has 40 judges, with 1 master, together with a small number of part-time deputy masters. I feel that there is a strong case for considering the creation of a group of experienced senior and legally qualified court officials who could deal with all aspects of the pretrial procedure which did not truly require the intervention of a judge. It is important to emphasise that I am not here suggesting that such persons would actually decide substantive issues, but rather that they could deal effectively and comprehensively with at least many aspects of the pretrial process. Judges would then be freed to be available to deal with those aspects of case management which truly require judicial input. In that context, experience has shown that a short hearing before a judge can often lead to a lot more progress in the pretrial process than lengthy exchanges of correspondence, and I would suspect, at least in some cases, a hearing before an official who did not have full judicial status. But be that as it may, it does not seem to me that the undoubted requirement for greater judicial resources it does seem to me that the undoubted requirement for greater judicial resources could be materially alleviated by the creation of a suitable number of appropriately qualified senior quasi-judicial officials. As a trivial point, I would question whether the name master is appropriate and fitting to such an office in the modern era, but the title is perhaps the least important part of the question. Before returning to judicial resources, it is necessary to say something about the trial process itself. Obviously, the most important function of any judge in our system is to conduct the trial of the issues and come to a ruling or judgment which is fair and in accordance with law on the basis of the evidence and the argument put forward, or in the case of a jury trial, to preside over the trial to make sure that it is fair and that the jury does that job. However, I think the public would again be surprised to learn how, in at least a significant number of areas, the judge who conducts a civil trial will know little or nothing about the case until immediately before it begins. There are often good reasons for this. For example, in the area of personal injuries, the High Court will typically list upwards of 15 cases each day. That will be done on the basis that only perhaps 3 or 4 of those cases could actually be heard should they not be settled. Successive judges in charge of the personal injury list have, of course, great experience at managing that list and in ensuring that the balance between the number of cases listed and the available judges to hear those cases reflects something which at least approaches a realistic estimate of what is likely to happen in terms of cases going on. However, the reality is that no one knows in advance the identity of the cases that are likely to be heard, and there would be little point, therefore, in asking judges to read documentation in advance where the list has to remain flexible in the context of only a limited number of cases going ahead. That situation is less acute, but nonetheless applicable in many other lists of the court. Likewise, a judge of the Circuit Court hearing civil cases is unlikely to have much information available in advance of the hearing. It is therefore only in a limited category of case that judges have traditionally been given the opportunity to read into the case in advance. I do not doubt that an expansion of the number of types of cases where judges can read in advance would improve the overall efficiency of the courts. But that being said, I would again emphasise the point that one size does not fit all, and applying a process that works in the commercial court to, for example, many categories of personal injury case, perhaps excluding clinical negligence cases, might be counterproductive in terms of maximising the best use of judicial time. However, it again remains the case that a reduction in that most expensive part of the court process, which is the conduct of the trial itself, can be achieved, but only if judicial resources are such that judges can be given time to familiarise themselves with the case in advance. There can be little doubt that an effectively managed proceeding, which required more focused and detailed statements of case, coupled with the opportunity of the judge who is to try the case to become familiar with the relevant documentation in advance, would, at least in a significant number of areas of litigation, potentially reduce by a material amount the time needed for the conduct of the trial, and thus significantly reduce costs. But the problem at present is that almost all available judges are required full-time to hear cases, and the capacity to allow judges time to familiarise themselves with the case in advance is therefore minimal. A similar and potentially more acute problem emerges in relation to those types of cases which require a reserved or written judgment. Ideally, as is the case in other jurisdictions, judges would routinely be given time off to write a judgment within a reasonably short time from the conclusion of the case. And I should say that increasingly the President of the High Court is attempting to introduce a model along these lines. Some flexibility in that regard might be useful because, having spoken to many judges on the topic, the precise model that would maximise the efficiency of the delivery of the judgment might well vary from judge to judge. Some might prefer the opportunity to write immediately after the case finishes and before they have a new case for trial assigned. Others, and I'll place myself in this category, would prefer a short period of time to allow the case to mull around in their heads before committing to paper. But whichever model might be favoured in specific cases, it would again require that there were sufficient judicial resources to allow judges the opportunity to write without being under competing demands, both to prepare for new cases and to sit to hear further cases. If a model where, in the vast majority of lists, a judge finishing a case is immediately launched into the next case, then if that is the model, then that time for reading in or writing judgments is just not available. I am mindful of the fact that the delivery of judgments within a reasonable period after the conclusion of a trial is an important part of the court process. Parties are under pressure inevitably in court proceedings, and a long delay waiting for the result is not in anyone's interest. But in order that it may be possible to ensure that judgments are delivered quickly, it is essential that the judges concerned have both the necessary time to write the judgments and to have suitable backup available to them to assist. It's also essential that judges are afforded the opportunity to be able to address the drafting of a judgment within a very short time after the case ends. Speaking from personal experience, I know that the amount of work which has to be put into writing a judgment grows significantly longer the more time that elapses since the case concludes. When the evidence and arguments are fresh in your mind, then it's a lot less time-consuming to at least produce a reasonable first draft. Where a significant period of time has elapsed, then there is much additional and ultimately unnecessary work in trying to put yourself back into the position in which you were immediately after the hearing in terms of understanding the arguments and familiarising yourself with the documents and the evidence. Delay in the timescale within which a judge can begin to start work on a judgment actually increases the overall or total amount of work which has to be done and contributes therefore to a classic vicious circle. It's important therefore if we are to move to a situation where realistic and relatively short timeframes are set for the delivery of judgments, and I favour moving to such a situation, that judges are not put in a position where the pressure to hear cases is such that they're required to forego the opportunity to at least produce a good first draft quite soon after the case concludes. But that in turn requires that there are enough judges available to enable court presidents or those in charge of particular lists to give judges that facility. On the other hand, with sufficient judicial resources, there can be little doubt but that, at least in a significant number of types of case, the system could be improved immeasurably by allowing judges time in advance and after the oral hearing to become respectively familiar with the case and afterwards to write a judgment. Before leaving this topic, I should mention in particular the position of the Court of Appeal. The fact that the Court of Appeal needs a significant increase in the number of its judges to enable it to handle the civil side of its business is a matter on which I've already commented. The very points which I've been making apply with particular force in the case of that court. If the hearings of the Court of Appeal are to be productive and efficient, then it is essential that all of the judges of the court have had a full opportunity to read into the case in advance. Not only is this likely to reduce the amount of expensive court time used, but it's also likely to increase the effectiveness of the process as a whole, for it will allow a more focused questioning and debate at the hearing. This can lead to greater clarity in the judgments ultimately delivered. Likewise, a great number of the appeals in the Court of Appeal will require a written judgment, or at least a ruling, which will take the judge concerned some time to prepare. It follows that the Court of Appeal just cannot operate on the basis of all judges sitting all of the time, for in those circumstances the judges would not be adequately prepared for forthcoming hearings and would not be able to produce proper judgments or rulings. Indeed, requiring judges of the Court of Appeal to sit all of the time would, in my view, be a classic example of a false economy, for the oral hearings themselves would then be likely to be longer, and there would be a risk that judgments would be less clear than they might otherwise be, thus running the likelihood of more applications for leave to appeal to the Supreme Court. It follows that the number of judges required to staff the civil side of the Court of Appeal must take into account not only the number of appeals likely to require to be decided, but also the fact that each judge must be given reasonable reading and writing time so as to be able to do their job properly. There are, of course, many other aspects of the court process which would bear consideration in the context of potential reform. In the criminal field, there is, for example, the question of the often lengthy periods during which jury trials are interrupted for legal argument. It will never be possible to entirely exclude the interruption of such trials where unexpected developments occur. However, and I think this is an issue on which Professor O'Malley's views might be very valuable, it may well be worth considering the possibility that those evidential and other legal issues which can be identified in advance should be determined by the trial judge prior to the empanelment of a jury. An attempt to at least go some way down that road was made at the time when the preliminary investigation procedure before the District Court in indictment criminal trials was abolished. However, the case law makes clear that the measures introduced at that stage do not permit general rulings to be made on matters such as the admissibility of evidence in advance of the trial, but rather have to concentrate on whether the case can go to trial at all. The so-called Unitary criminal trial is rightly considered to be an important part of our system. However, it does not seem to me that it necessarily follows that all of the elements of a Unitary trial must take place after the jury has been impanelled. It would, however, be important, I think, that the same judge who is to preside over a jury trial and who would therefore be familiar with the case would conduct any determination of issues which were required to be decided prior to the full trial before the jury commencing. But is there any reason why any major issues which could reasonably be identified in advance could not be debated with the trial judge before the trial commences so that appropriate rulings could be made? It's surely not fair to jurors, and in my view does little or nothing to add to the integrity of a criminal trial, to have jurors impanelled and then sent home for significant periods of time to enable legal rulings to be made. On the civil side, issues such as the difficulty in certain types of cases of complying with discovery obligations, the obligation to disclose documents relevant to the case, have been well signalled in recent years. There can be little doubt but that discovery costs have become, in at least certain types of cases, almost prohibitive and are acting as a significant barrier to access to the courts in cases thereby affected. I might mention that I was speaking at a seminar organised by the Commercial Litigation Association of Ireland a few weeks ago when one of the contributors, a leading senior counsel in the area, made the point that he knew that the question of civil discovery, which would be an issue that not too many people outside the legal profession, and even quite a lot of people within the legal profession, would be overly familiar with, that its day had come when he turned on his radio as he was driving around Dublin on a Saturday morning and found Marion Finucane asking the Chief Justice about discovery. It must be a very important issue if it reaches that stage. But the truth is, it is a big issue. It is a huge barrier to cost-effective litigation in many areas. I was first persuaded of that fact when I was conducting the case management of proceedings brought in Ireland arising out of the collapse of the empire of a certain Bernie Madoff, an American financier who ran off or made off with a lot of money, but the money was mainly gone, and there were proceedings. There was meant to be about €1 billion worth of money in the IFSC. When people went to look for it, it wasn't there, in a surprise development. And there was no point suing Mr. Madoff because he was beginning a 127-year jail term. But there was a case being brought against certain financial institutions whom it was said had not exercised their duties in respect of minding the money in a proper way. I don't want to comment on the merits of the case. What was an eye-opener to me was that I was told that the discovery obligations on one party in that case were likely to cost €7 to €8 million to comply with. And that was not money that was going to be spent giving large fees to a small number of lawyers. It was just that the volume of work that required to be done in sifting through a huge volume of electronically stored information was such that it required a very large number of relatively junior lawyers to spend an awful lot of time doing it. I'm also aware of one recent case where the process involved upwards of 20 young lawyers working for 2 years to comply with the disclosure obligations. Now, it's a valuable resource. It requires parties to, as it were, put their cards on the table, hand over documents that may be relevant to the case, and in some cases it can make a real difference to the ultimate outcome, and a just ultimate outcome at that. But at the same time, it can be a huge cost in every case, and whether it's always justified is open to considerable debate. But again, it's an area where there is no silver bullet, but I'm sure that that is one of the issues which the Kelly Committee will address in the course of its deliberations. Doubtless, many other examples of specific issues which are causing potential difficulties in the court process could be identified, but I hope I've sought to address the key issues which will need to be considered if we are to bring about true reform in the court process. That leads me to one final point. I've again commented regularly in recent times that the fact that the level of assistance or backup given to judges in the common law world, and I have to say Ireland in particular, falls a long way short of that which is made available in other jurisdictions. At present, a judge of the Irish Supreme Court shares one researcher with another judge. In many other jurisdictions, a much larger number of judges sitting on their Supreme Courts have 2 or 3 assistants each. At the level of trial courts, I think the position is even more acute. There is a group of judicial assistants or researchers available to the High Court, but it seems to me that the amount of additional judicial time which will be required to deal with matters in the manner which I have just described as desirable could be materially reduced by the availability of additional backup staff. Assistance in reading papers and identifying those aspects of the documentation which seem to be central to the case might materially reduce the amount of time that a judge, him or herself, would need to spend on that task. Assistance in correlating uncontroversial facts or evidence for the purposes of writing a judgment would likewise reduce the amount of judicial time required to be deployed. Many other examples could be given. It seems to me that the moral of that story comes back to a point which I've made before on a number of occasions. An improved system requires, almost inevitably, better ways of using existing resources, but also more resources. I've attempted to identify some areas of our process which could be significantly improved, but that will not be done, or certainly at least not done in any truly effective way, without the deployment of extra resources. But I would emphasise that not all of the additional work which needs to be done must be done by judges. The availability of suitable high-level quasi-judicial officials could remove much routine pre-trial work from a judge's desk. The availability of appropriate backup could reduce the amount of judicial time which is required to be spent in reading in to either applications or full hearings or in writing judgments. But the combination of the significant increase in the amount of routine pre-trial work which would not have to be done by judges, an increase in the number of judges, and the availability of greater backup to judges could allow many significantly improved processes to be put in place in our court system. That, coupled with the facility to provide a modern judicial training programme and the delivery of much enhanced information to judges, could lead the way to a significant reform of our courts, leading into the second century of their creation. Thank you very much.
Thank you very much, Chief Justice, for setting out such a comprehensive analysis and also programme for reform, and reminding us also of the upcoming centenary of the establishment of independent courts in independent Ireland. So I'm going to hand you over now to our colleague, Tom O'Malley, who's a senior lecturer in the law school here and a member of the Law Reform Commission, and who is a practicing barrister who, throughout both his academic and practice career, has specialised in the areas of judicial review, also in laws relating to sexual offences and criminal procedure, and in the analysis of sentencing law and procedure. Tom is a graduate of NUI Galway and also of Yale University. He was a graduate fellow at Yale Law School in 1986 and 1987, and since then has taught at NUI Galway. He has also held visiting positions in Leiden, Oxford, Paris, and is regularly invited to lecture and speak on the topics of sexual offences, criminal procedure, and sentencing policy. He's published widely in these fields and is one of the most widely cited of Irish legal academics. So delighted now to introduce and hand over to Tom. Thank you.
Thank you very much, Siobhan. And I'm delighted to be here and to welcome the Chief Justice amongst us, and for the very fine paper he has given. In fact, the topic I'm going to discuss principally is about the allocation of criminal jurisdiction, but what the Chief Justice has said seems to me to be uniquely important, and therefore I want to go off script, if you like, at the beginning, just to make a few points about it. I had the privilege of reading his paper just before he gave it, because it is important that we have some new thinking in this particular area, and where many efficiencies should be brought. For example, just to take one thing that comes to mind, any of us who have experience of appearing regularly in the High Court, especially in certain lists, including the Judicial Review list, can only be struck by the amount of time the counsel actually spend reading out pleadings, which may very often take up half the amount of time which is allocated for the case, despite the fact that those pleadings have already been lodged with the court itself. The reason being, of course, that the judge who has been assigned to hear the case doesn't know what cases he or she will be hearing until they arrive before him or her, and that's the reason for it. Ideally, of course, there should be procedures in place whereby the judge would, first of all, be allocated well in advance, and also, as the Chief Justice has said, have the opportunity to read into the papers beforehand. Listening also to the Chief Justice's remarks, and bear in mind that we're here at a university, it also prompts some thoughts about the role that the university and law schools might play in this area. Civil procedure is a topic that is neglected in law schools, law school curricula, certainly in these islands at least. Criminal procedure tends to fare a lot better because so much of it nowadays comes within the purview of constitutional law. Article 38(1) of the Constitution, which guarantees a fair trial, is probably the most frequently litigated provision of the Constitution, which means that some of that at least will figure in courses on constitutional law, evidence, criminal law, and so forth. Now, it's sometimes said that there is little point in trying to teach civil procedure in an academic environment because it's something that you can only learn by doing. There is, of course, some truth in that as far as the detail is concerned. Nobody wishes to inflict the rules of the superior courts on law students. In fact, most of us as practitioners would prefer to be saved from them as well. However, there is a potential for a scholarship of procedure, just as there is a scholarship of areas of substantive law. An academic course on procedure, and civil procedure in particular, could concentrate on the structures and values that underpin the administration of justice. I'll just give one or two examples. Like other common law countries, we have an adversarial system. Chief Justice mentioned that. One feature of this system is that it is the parties that determine the nature and the parameters or the contours of the dispute that is to be determined by the court. In the legal literature, it's often defined as an agonistic system. That word is interesting. Agonistic comes from the Greek word agon, which means a contest or a test of strength. It was often used to describe what was happening at the Olympic Games in ancient Greece. And in the very same way, under our system, the adversarial system, it's premised on the assumption that the best way of discovering the truth and administering justice is by the presentation of competing narratives of fact and competing submissions of law to an independent and impartial decision maker. This is probably a fair assumption, but like all others, it needs to be subject to ongoing analysis and critical evaluation. In terms of the detail of civil procedure, it might very often seem to be overwhelming, if not confusing, if it was studied or taught in isolation from practice. Yet much of it is designed simply to ensure fair procedures and to prevent one party from having an unfair advantage over another. That is the essential idea underpinning the rules governing, let's say, the service and the filing of pleadings and other documents, as well as the rules relating to disclosure and discovery. So that's the kind of perspective from which it might be that procedure might be studied and researched at academic level. Civil procedure is a staple of American academic legal education, which is usually taught as a mandatory first-year course, supplemented by other things like moot courts and so forth. There is, of course, a big difference between their system and ours. Our system of professional legal formation involves 3 stages: the academic stage, usually at university level, the training stage, carried out in this country by the Law Society and the King's Inns, and then the experiential stage, which is in the form of a traineeship or a pupillage. In America, of course, they don't have the second of those. There is no training stage, and indeed there's very little at the third stage either, which means that law schools have a much greater role in preparing students for legal practice as well as providing an academic legal education. Having said that, university law schools in this country, I think, could devote much more thought to how they might develop and encourage students to think about the structure and the values of the legal system in which they will be playing vitally important roles. So-called clinical legal education and work placements are increasingly being seen as ways to achieve that end. I'm not convinced by the value of either of them. Clinical legal education, as it operates in this country or as is understood in this country, often amounts to little more than organising short-term work placements, even though most students will actually get that anyway shortly after they graduate. American-style clinical legal education, if it were possible to adopt and adapt, would be much more valuable because it would allow students to become immersed in a particular legal problem and see it through in procedural and other terms to some kind of conclusion. The years spent at university are often the only ones, or the only time, in which future lawyers are given the idea, the opportunity, I should say, to think critically about the system of which they are to become part. That is why I would strongly encourage the development of genuinely academic courses in legal procedure and court organisation. I think that having a cohort of law graduates who are equipped to think critically about these matters will be of great value to the legal system and therefore to society at large in the future. Now, moving on then to just the specific issue of the allocation of criminal jurisdiction, and I have a paper prepared on it, which I won't read out all of it because it's more important that there should be time for discussion. But as the Chief Justice said, we are approaching the centenary of the establishment of our court system. And indeed, we're in this era of centenaries, which will, by some reckonings, end in 2022 with the foundation of the state. Yet I think it would be a mistake to ignore what happened in the 2 or 3 years after that, what Tom Garvin has called the long 1922, and in particular the extraordinary legislative achievement of the Free State government during those early years. The Ministers and Secretaries Act of 1924 set up the entire administrative structure of the state, still exists, as did the Courts of Justice Act of the same year when it established the court system. Both have proved to be remarkably enduring, and indeed the same is true of other legislation passed in that era. Just to say a little bit about the court system, in 1923, the Executive Council, the government of the day, established a 12-member Judiciary Committee chaired by Lord Glenavy, or James Campbell, to advise on the establishment of a new court system. There was admittedly some urgency about it because at that time you had the British courts, as they're called by historians, and the Dáil courts, and they were in competition with one another. Glenavy's appointment was in some ways surprising because he had been such an establishment figure under the old regime. But on the other hand, he was a committed unionist, a former MP, a member of the Masonic Order and so forth. On the other hand, he had accumulated considerable legal experience, having successively been Attorney General, Lord Chief Justice and Lord Chancellor of Ireland just before independence. He certainly found favour with the Free State government, which also appointed him to the Senate, of which in fact he was the first chairman. None of this prevented him, I might add, from showing occasional contempt for the new political order. He insisted on pronouncing Seirstad Éireann as Sour State Iran. Incidentally, we can also properly thank him for having saved the traditional wig and gown worn by judges and barristers. Hugh Kennedy, who was then the Attorney General and later Chief Justice, wanted to replace this garb with a new uniform, a very colourful one by all accounts, modelled on what he believed Irish Brehon judges would have worn centuries earlier. Glenavy ridiculed this idea, saying, and I quote, he said, "Remember, this is a thing that can be altered and re-altered by each successive Minister for Home Affairs. The present Minister for Home Affairs might prefer a kilt," which he actually did. His successor might be a sporting man and he might prefer a jockey's costume. Maybe there was something prophetic about that. And his next successor might have clerical tendencies and he might prefer the judges robed in clerical costumes. Where is this thing to end? Well, in any event, the Judiciary Committee concluded its work within 4 months, and while it didn't produce a report, it produced a set of recommendations which became the Courts of Justice Act of 1924. And in a sense, it has, as the Chief Justice has said, remained pretty much intact. I suppose the most significant change as far as the criminal courts are concerned was the establishment of the Special Criminal Court in 1939, for which provision is made in the Constitution. Now, I'm not going to talk about that, about the Special Criminal Court here, because I'm more concerned with the ordinary courts, although there is much that could be said about it. It is, the framework for it is provided for it by the Offences Against the State Act of 1939. Even today, under that law, the government is entitled to decide on the composition of the court, which can include, don't forget, army officers as well as judges and lawyers. However, I think it's certainly true today that it would be utterly incompatible with present-day constitutional standards for the judges of the court to be anybody other than serving judges. There is, however, one rather disturbing provision in the Constitution, which is in Article 38(6), dealing with that court, and it said that the provisions of Articles 34 and 35 of the Constitution shall not apply to any court set up under the Section 3 and Section 4 of this article. Now, you don't have the Constitution in front of you, but effectively it's saying the Special Criminal Court is not subject to the provisions of Article 34, which require, for example, that justice shall be administered in public, or, more worryingly, Article 35, which requires, and I quote, that all judges shall be independent in the exercise of their duty. I think it is not acceptable in this day and age that we should have a criminal court with virtually untravelled jurisdiction, as is true of the Special Criminal Court, which could consist of persons who are not, in fact, expressly subject to a constitutional obligation to exercise judicial independence. Arguably, Article 6 of the European Convention of Human Rights provides a sort of safety net, as it provides that everybody who is charged with a criminal offence, without distinction as to which court they're tried in, is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. But certainly those are some aspects of the Special Criminal Court that could be looked at, I think, with some profit. Just to say something then about summary jurisdiction, the District Court. As I said, the Galway Committee didn't submit a detailed report. But one of the things that it clearly did was to reject the idea of a lay magistracy. Prior to independence, much of what we now call summary jurisdiction in the District Court was in fact carried out by lay magistrates of one kind or another. Instead, it recommended in effect that all judges of all courts in this country should be professionally qualified, and that included the District Court as well as all of the other courts. In fact, it was to recommend that judges of the District Court would in fact be remarkably well paid, $1,000 to $1,200 a year, which was good money back in 1922, in order to ensure their independence. And this remains a distinguishing feature of the Irish legal system today. Judges of all law courts are professionally qualified, have to have a minimum number of years in practice. In England and Wales, on the other hand, summary jurisdiction is exercised by a vast army of about 21,000 unpaid lay magistrates who typically sit 13 days a year, though there are some full-time magistrates as well who are now known as district judges. The professional nature of our District Court has made it possible to assign a very significant level of criminal jurisdiction to it. Indeed, the District Court's criminal jurisdiction has expanded remarkably since 1924 because of a number of factors. It has always had exclusive jurisdiction over summary offences. However, ever since 1951 in particular, the Criminal Justice Act of that year, it has gained extensive powers to deal with indictable, that's serious offences, provided they are judged to be minor in nature. It has become increasingly, in addition to that, increasingly prevalent for legislation to define offences in such a way that they can be tried either in the District Court or on indictment at the option of the prosecution. Another very significant development occurred in 1984 when the Criminal Justice Act of that year increased to 2 years the total term of imprisonment which the District Court is empowered to impose for a combination of offences. The District Court therefore has a crucial role within our legal system. It is there that virtually all criminal cases begin and also where most of them end. However, we probably need to invest more heavily in the District Court. A judge who is appointed to that court, irrespective of the nature of his or her previous practice and experience, must immediately begin applying a vast body of law, civil and criminal. He or she will be expected also to apply a never-increasing and complex set of legal rules, relating to evidence and procedure. For that reason alone, there should be more investment in training, induction, and continuing professional development. It is also essential that there should be adequate judicial support systems in place so that district judges and indeed practitioners appearing before that court should be made aware on a systematic basis of new development, including relevant decisions of the superior courts in judicial review and case-stated proceedings that apply to them. I'll move on just to say something about the higher courts and in particular about the division of jurisdiction between the Circuit Court and the Central Criminal Court. The vast majority of serious cases are dealt with in the Circuit Court. However, the High Court, under its guise as the Central Criminal Court, has been granted exclusive jurisdiction over a small number of offences, the most prevalent being murder, rape and aggravated sexual assault. The division of jurisdiction between these two courts is somewhat arbitrary, to put it mildly. If we take as our starting point, let's say 1961 and the Courts Act of that year, it effectively conferred jurisdiction on the Circuit Court over all indictable offences, apart from treason, murder, and a few offences which, to the best of my knowledge, have ever been prosecuted under the Offences Against the State Act of 1939. The next major development came with the Rape Act of 1990, I should say, which provides that rape offences and aggravated sexual assault offences are to be tried in the Central Criminal Court. The Law Reform Commission had recommended this move, partly because of the inherent gravity of the offences in question, this rape and aggravated sexual assault, but partly because it believed that more jurisdiction should be returned to the Central Criminal Court. However, when introducing the legislation in the High Court, in the Dáil, The Minister for Justice made it clear that it was solely because of the gravity of those offences that jurisdiction over them was being returned to the Central Criminal Court. Supporters of the change cited other reasons, including the hope that sentencing might become more consistent if it was exercised by a small number of High Court judges who would henceforth be dealing with all such offences. In the meantime, then, the Competition Act of 2002 made certain competition offences triable in the Central Criminal Court only. Various other statutes which have made genocide, torture, a few maritime offences and so forth triable in the Central Criminal Court as well. So overall, it has been a rather haphazard division of labour, if you like. Sure enough, competition offences can cause their share of difficulties, but mainly at the level of investigation and prosecution. Some are punishable with very significant fines running to millions of euro with the possibility of imprisonment for individual offenders. However, most of the cases dealt with so far have resulted in very modest fines being imposed, and a few suspended prison sentences have been imposed on offenders. If you contrast this, for example, with the Health and Safety Legislation, 2005 Act, again, very high maximum sentences are available with the possibility of imprisonment. But these offences, again, are all dealt with in the Circuit Court. And, in fact, unlike competition offences, they have often attracted very high penalties indeed. Bus Éireann, for example, some years ago was fined €2 million in respect of a collision in which 5 people died. More recently, a transport company was fined €1 million in respect of an incident in which 2 people died and a number of others were injured. The latter fine, by the way, was upheld by the Court of Appeal. In terms of complexity, therefore, it is difficult, if not impossible, to argue that competition cases are inherently more complex than health and safety cases, not to mention, of course, complex frauds, all of which are dealt with in the Circuit Court. Mention of competition offences brings to mind one possible defence for having transferred them to the High Court, to the Central Criminal Court. Mr. Justice McKechnie, who presided over a number of such trials, delivered 2 significant sentencing judgments, one of which has been formally reported, the Duffy case of 2009. This was and remains a very valuable judgment which closely analyses the principles governing the sentencing of such offences. If the delivery of such judgments in the Central Criminal Court became the norm, there might be a case for assigning more jurisdiction to that court. Unfortunately, that is not the case. The judgments database on the Court Service website contains no more than 16 written judgments by the Central Criminal Court between 2007 and the present day, and half of those were all delivered by the one judge, Mr. Justice Sheehan. I think it's regrettable that judges of that court have not delivered more sentencing judgments in particular, because by so doing they could demonstrate how they were going about applying certain principles and in the process promote a valuable debate on key sentencing issues. There is neither rhyme nor reason at the present time to the allocation of criminal jurisdiction over sexual offences. Provided, as I said already, rape and aggravated sexual assault were assigned to the High Court, the Central Criminal Court, in 1990. We're now in a situation where, provided the indictment includes a rape or aggravated sexual assault charge, the case must be tried in the Central Criminal Court. Otherwise, it would be tried in the Circuit Court. So if a person, for example, were accused of serial child sexual abuse, and unfortunately you have many very serious such cases coming before the courts, but if all the offences charged, and this sometimes is the case, involve sexual assault, incest, and what is often called defilement, which is effectively sexual intercourse with a person under a specified age, that person will be tried in the Circuit Court, because there is no rape or aggravated sexual assault involved, whereas a person who is charged with even one count of rape will go on trial in the Central Criminal Court. Very recently, about the Criminal Law Sexual Offences Act of 2017, a major piece of legislation, introduces many new sexual offences against children and persons with mental disabilities, and it amends the definition of many others. Yet all of these offences will be tried in the Circuit Court. To the best of my knowledge, the possibility of transferring them to the High Court wasn't even discussed in the course of the deliberations in the Oireachtas. Indeed, a similar observation might be made about homicide. Murder is quintessentially, you might say, a High Court offence. It's one of the offences that must be tried in the High Court. And of course, it is the most serious offence that we know of, apart from genocide. Manslaughter, on the other hand, is tried in the Circuit Court. So if you have somebody who's charged with murder, well then, unless they're acquitted, they may be convicted of murder, but they may also be convicted of manslaughter in the High Court. Yet, if a person is charged with manslaughter from the outset, of course, the case will be dealt with in the Circuit Court. Now, murder cases are indeed complex, but sometimes not. The same can be said about manslaughter. When one considers some recent cases that have come before the English courts, where the law is pretty much the same as it is here in terms of the definitions of murder and manslaughter, the English courts have recently dealt with a number of very difficult cases involving manslaughter by gross negligence, manslaughter by unlawful dangerous act, and so on. And it becomes quite clear that manslaughter trials can be just as legally complicated as murder, and sometimes more so in fact. So therefore we need to give serious consideration to what is the proper role of the Central Criminal Court, should it remain in existence, bearing in mind that in all contested trials, it is the jury who decide on the guilt or innocence, or well, I should say the guilt or otherwise of the accused. Juries are drawn from the same population, irrespective of whether they are called upon to serve in the Circuit Court or the Central Criminal Court. Indeed, the latter court, the Central Criminal Court, sits almost exclusively in Dublin, so one must ask if it is appropriate that virtually all murder and rape cases should be decided by a jury drawn from the same limited geographical area, irrespective of where the alleged crime actually occurred. Now, I'm mentioning all of this because, as you know, since the economic crisis of 2008, there has been a great deal of pressure to have more enforcement of white-collar crime and of corporate offences, and for the creation of more such offences. And it has been suggested by some, though I haven't heard it myself, but I believe this is the case, that more of those offences should be held or should be tried in the High Court, just to emphasise their gravity. Now, I'm going to skip over some of what I'm saying about that, but essentially what I'm saying is that it's very important that we be economical in the creation of criminal offences. The problem is at the moment that we have too many, not too few, white-collar and corporate offences, but most people don't know that they even exist. It's far more important that we have a number of properly focused, well-defined offences, rather than a plethora of ones that don't exist and that very few people know about. I believe that they can be tried just as easily and as well in the Circuit Court as in the Central Criminal Court. The only reason for having them, or indeed most other offences in the Central Criminal Court, is that it has a kind of an expressive quality. There's no doubt that legal decisions generally do have an expressive function. I mentioned in the paper a classic piece of work by Joël Feinberg about the expressive function of punishment, one of the best-known pieces of writing in the field of criminal law over the past half-century or so, talking about how that is one of the if you like, principal functions of imposing punishment on people, is it gives expression to our condemnation of the wrong that was done, or the harm that was done. And likewise, I suppose, the level of court in which a case is charged has a kind of an expressive quality about it. But I think at the same time, it's important not to overstress that point. That's why, in essence, what I'm saying is that we need to look at, I think the time has come for a certain re-examination of the division of powers between the Circuit Court and the Central Criminal Court. I would then like to conclude, because it's relevant to the whole question of criminal court jurisdiction, to say something about sentencing reform, which I hadn't planned to do. But because it is so much in the news, even today, I just think it's important to say something about it. We do retain, as we all know, a highly discretionary sentencing system in this country. We don't have guidelines. Always important to remember that we are not alone in that regard by any means. We're apt to forget that apart from England and Wales, Scotland, which is just in the process of developing guidelines, and some but not all jurisdictions in the United States, that all other common law jurisdictions and many Western jurisdictions simply don't have any guidelines either. So we are, if you like, not the exception, we are in a sense part of the rule. The idea of discretionary sentencing can be defended morally and philosophically. I refer here to, but I'm not going to bore you with it, I have written about it elsewhere if you want to be bored, that you can go back as far as Aristotle in his famous book on ethics, written in the 4th century BC, where he famously talks about the different kinds of intellectual qualities that people can have, and he names one of those in the original Greek as phronesis, which we usually just translate into English as practical wisdom or prudence. And he says that there are some people, the ideal statesman, for example, is gifted with this thing called phronesis, practical wisdom. And the person who is endowed with practical wisdom is somebody who understands the theory, but is able to apply it in a sensible way to concrete problems that come before them. And that kind of thing has, that is, if you like, one of the justifications why, or that is one of the bases on which you can defend discretionary sentencing. I remember in a book that I published on, it's not the sentencing book, but a shorter work I published back in 2011, writing about that. And sometime after that, a guy in England phoned me up or got in contact and said, do you think there's room for a PhD on this topic of sentencing as practical wisdom? And I said there is. I encouraged him to do so. And then he came along and wrote a book about it. Only last year, Criminal Sentencing as Practical Wisdom. So certainly that has caused a bit of ructions in England because most academics there are very much in favour of guidelines, and they see him as having, if you like, rained on their parade. So although I'm keeping very quiet about the fact that I was responsible for putting the bad idea into his mind in the first place. Now this Aristotelian vision, as I'll call it, this idea that there is value in discretion, value in practical wisdom, is, I suppose, the principal justification for individualized justice. The idea that it is important that we should sentence each case according to its merits and to its particular circumstances. One of the most revered statements on sentencing in this country is that of Mr. Justice Barron in a case called McCormack back in the early 2000s, where he said, and I quote, "Each case must depend on its own circumstances. The appropriate sentence depends not only upon its own facts, but also upon the personal circumstances of the accused. The sentence to be imposed is not the appropriate sentence for the crime, but the appropriate sentence for the crime because it has been committed by this particular accused. The range of possible sentences is dependent on these two factors. However, in light of present-day values, regard must also be had to distributive justice. So individualized justice means concentrating on the individual. Distributive justice means having a set of principles to ensure as far as possible that similar cases are treated in a similar way, or to phrase it more precisely, I suppose, to try to ensure that similarly situated offenders do not, if they commit similar offences, receive markedly dissimilar sentences. The sentence a person receives should not depend solely or largely on the court before which the accused person appears, nor should it appear on the personal ideas, preferences or values of a particular judge. This is the core of the argument in favour of structured sentencing, whether through the adoption of guidelines or by some other means. In a democratic polity, a democratic system, the law should be made by the legislature, consisting of elected representatives of the people. It is the legislature, it is its role to decide which conduct should be treated as criminal and also to specify the mandatory minimum or maximum sentence for each offence. Now, most common law countries, including ourselves, the vast majority of criminal offences are governed by maximum rather than mandatory penalties. That's, I think, the best way to have it. But it's also widely agreed that in a constitutional democracy, the selection of punishment in individual cases should be exclusively a judicial task. So therefore, you have two ends of the spectrum. At one end, it is up to the legislature to make the law in general terms, At the other end of the spectrum, it is up to a judge to decide on the punishment to be imposed in each case. But there is an important decision-making role in between those 2 points, and that is the decision as to what the principles should be. Who should actually determine what we call the distributive principles of punishment? Who should decide how much is appropriate in certain circumstances and what kind is appropriate in certain circumstances? And that's where the debate is. The debate is focused on that particular question: who should actually develop the principles and how detailed should the principles be? Now, hitherto, in these islands generally, well, certainly until very recently in all jurisdictions in these islands, and indeed throughout the common law world, it was the judiciary who fulfilled that middle role as well. They developed the principles in broad terms, principles like there shall be a discount for a guilty plea and so forth. And that is the way, for example, it was in England and Wales until about 20 years ago, when they set up a more structured system. And therefore, the significance of having formal sentencing guidelines where they exist, such as those in, let's say, England and Wales and in the United States, is that the role, if you like, of deciding the distributive principles is taken away from the judiciary and given to an independent body such as an agency. So that while the judiciary is still charged with developing sentencing guidelines, while the judiciary under that system, the guideline system, is charged with selecting sentences in appropriate cases, that is appropriate to each case, it must do so in accordance with guidelines which either recommend or mandate the sentence range that is appropriate for each case. Now, sentencing guidelines take many forms. For many years in England and Wales, they were judicially developed, beginning in earnest in the early 1980s when the Court of Appeal began to identify sentence ranges for certain offences. Many people will be familiar with the case of Bilham of 1986, where the court established the appropriate sentencing ranges for rape. Here in Ireland in 2014, the former Court of Criminal Appeal, presided over on that occasion, as it happens, by Mr. Justice Clarke, as he then was, recommended somewhat similar sentence ranges for 2 offences, causing serious harm and the possession of a firearm in suspicious circumstances. Those 2 judgments have proved very useful and have been applied in both trial courts and the Court of Appeal, which replaced the Court of Criminal Appeal 2014. However, since the establishment of the new Court of Appeal, it has not delivered any guideline judgments of this kind, although in its defence it must be said that it has been snowed under with cases civil and criminal, and it has delivered judgments in an enormous number of appeals since it has been established. Pressure is now growing for the introduction of some kind of sentencing guidance in Ireland. Indeed, there has been quite a significant attitudinal shift here over the years, right across the board. When I started working in this area more than 30 years ago, the idea of sentencing guidelines was regarded as nothing short as heretical by judges and lawyers, but there is now a great deal more receptiveness to the idea, and it is fair to predict that we will see some kind of guidelines developed in the years ahead. But in light of the pressure that's now beginning to build up in the media and elsewhere, and even at political level for them to happen, I would enter a note of caution. Some of the present media commentary and political observation might suggest that the development of guidelines is a fairly easy, simple and straightforward task. Nothing could be further from the truth. Sentencing is inherently a difficult and complicated task, and no guideline can make it any different. Unless there were to be some crude system of mandatory sentencing, which would be scarcely fair or unconstitutional, guidelines must be sufficiently detailed and fine-tuned to reflect and accommodate the many different circumstances in which particular offences can be committed, considering varying levels of gravity, culpability, variations in the personal circumstances of offenders and so forth. And that, of course, is quite difficult. I occasionally have some dealings with the English Sentencing Guidelines Council, and only before Christmas was involved in certainly a very interesting seminar in London, because they very often bring different constituencies of people together, where we were discussing a new draft guideline on sentencing terrorist offences. And again, it is just very interesting to see the sheer complexity of it, how do you sentence someone who sends a woolly jumper to their son who is fighting for ISIS as a Christmas present, as opposed to somebody who goes out and starts campaigning for people, encouraging people to go and fight for ISIS, that kind of thing. And the same, of course, is true right across the board for a whole wide range of offences. What judges can realistically do is to promote, what guidelines, whether they're developed by judges or anybody else, what they can realistically do is promote consistency of approach. Now, there's always a distinction to be drawn between consistency of approach and consistency of outcome. Very often what people want is consistency of outcome. In other words, to see people getting the same sentences if they commit the same kind of offence. Consistency of approach is much more important, because what is involved there is to ensure that that all judges, if you like, would apply the same criteria when assessing the gravity of an offence, and also, although this is more difficult, apply the same criteria when assessing the weight to be attributed to factors that are personal to the offender. But there are always difficulties. One particularly difficult question is the priority to be accorded to any one of the standard purposes of punishment: retribution, deterrence, rehabilitation. The sentence imposed for a particular offence can vary enormously depending on whether the particular judge, for example, favours rehabilitation or deterrence in the particular case. In fact, in a judgment delivered yesterday, which gives you an idea of how recently the present paper was written and how well in advance it was prepared and so forth, but in any event, in a judgment delivered yesterday, the Court of Appeal dealt with that particular issue as it happens in the case of O'Brien, where it said that it didn't believe that the courts should, if you like, adopt any one purpose of punishment like rehabilitation or deterrence or retribution for all cases. It said, we prefer an approach in which the correct prioritisation of penal objectives is to be determined by the circumstances of the particular case based on the evidence. We readily accept that in many cases it may be appropriate to prioritise rehabilitation. There will, however, be cases where it may be appropriate to prioritise deterrence, retribution or incapacitation. Now, I agree fully, as it happens, with that observation, but I would add that it would be desirable to have some general principles or guidance as to when one of those objectives is to be preferred to another. So therefore, in conclusion, what I would say is that the development of guidelines involves a two-stage process: the descriptive and the normative. At the first stage, a process needs to be established whereby reliable information can be gathered about sentencing practice, and in particular about the sentences that are upheld or varied on appeal. This is something that the Sentencing Council, that the Chief Justice mentioned, can perhaps have a strong role in, as the statute envisages, in fact. This has to be an ongoing exercise, and in light of the resources that are likely to be available, it will have whoever does it will have to be selective in the sense of concentrating on certain commonly prosecuted offences and others that are viewed as problematic. When that information is available, one can then progress to the normative stage, which involves developing guidelines which indicate what the appropriate sentence ranges for commonly prosecuted offences should be. Again, I talk about sentence ranges. I think there always has to be, if you like, a certain, you cannot lay down a correct sentence. One of the great sentencing scholars of the 20th century, Norval Morris, used to say there is no such thing as a right sentence for any offence. The challenge is to ensure that the courts don't impose a wrong sentence, in the sense of a sentence that is, or a penalty that is outside acceptable parameters. So really what guidelines are trying to do is to establish, as narrowly as humanly possible, the correct parameters within which a sentence might be appropriate. And then the final question is, who should develop this guidance? Essentially, there are two choices, as I see it: appeal courts or a specialised agency established for this purpose. England and Wales has had experience of both. Guidelines began to be developed by the Court of Appeal, but then was taken over by the present Sentencing Council. At this point, I would favour judicially developed guidelines for serious offences, preferably developed by the Court of Appeal, though I also would emphasise that the court will need significant additional resources if it is to fulfil that task adequately. Of course, the Court of Appeal never has the opportunity to adjudicate upon sentences imposed at district court level, and as I noted earlier, That is where the vast majority of offences, including most road traffic offences, are dealt with. More general guidelines may have to be introduced for the District Court, something similar to the Magistrates' Court's guidelines in England and Wales. The District Court Judiciary might be encouraged to take this initiative themselves in the first instance, and they could concentrate on looking at the question of custody thresholds, where, at what point should an offence or an offender be deemed to have reached a point where imprisonment is inevitable. But either way, all the omens are that guidelines are on the way, but we must be very careful as to how we go about developing them. So thank you very much for listening.
Thank you very much, Tom, for expanding the debate around court reform and bringing forward further new questions for us to consider. I'm going to open up to you now to take some questions. The Chief Justice has very kindly agreed to respond to any questions that you may have, and if I could ask you to be brief if you can, to exercise practical wisdom, and to just give me your name when you raise your hand, please. Please, Ronan. I'll take a few questions together if that's okay. Yeah, thanks. Oh, here. Sorry.
Thank you. Ronan Kennedy from the School of Law here. I think that my first-year Irish legal system students would welcome any efforts that would simplify the system of appeals, because I think that learning how the system is laid out is one of the challenges that they have. But maybe it's a point of detail, but I would like to get just a bit more clarification maybe on one of the things that you mentioned. You talked about the idea of issues in criminal cases being dealt with before the jury is actually impanelled. And I wonder, would you see those decisions as themselves something that could be subject to an appeal before the jury would then later be impanelled? Because that could save time on a certain perspective, but also creates a possibility of a particular prosecution ping-ponging its way back and forth between appeal courts as successive legal issues are dealt with, which is obviously not in the interest of the accused, who's in theory innocent, and also not in the interest of the victim.
I'd be interested in Tom's view on that as well.
Yeah, please.
But I think in a way they're slightly two different questions. Question one is, would it make sense to, for example, if there's going to be a big issue about the admissibility of the statement, do you decide that there's going to be a trial within a trial? Do you have that before the trial, or do you have a jury sitting at home for 2 weeks waiting for that to be finished? Personally, I think there's a case to be made for doing it in advance. But even if you do that, it doesn't necessarily follow that you allow an appeal from that decision at that stage. I suppose in that case, depends on the result. If the answer is it's out, then possibly the case collapses. And if the case is not sustainable without the statement being admitted, possibly there's then going to be a nolle prosequi. It might be in a certain case there'd be enough evidence left that it could still go to the jury. Perhaps the best option would be, I should say in most cases, and this can happen in perhaps even more in civil cases, where we do sometimes now have so-called modular trials where some issues are dealt with first. And one of the arguments against it is then you have an appeal and the appeal is successful and you're back and it's a great mess. And I think by and large appellate courts are increasingly of the view that it requires something special before it makes sense to have an appeal until the whole thing is done, that the longest way round may be the quickest way home, that there might be occasionally cases where it is so vital to the case that it makes sense to have an appeal, but by and large, you're maybe better finish off the case, including whatever rulings are made in advance, and if either the DPP is unhappy with the result and wants to appeal within the circumstances, the DPP can, or if the accused is unhappy, then everything can be dealt with in one go. But I would be interested in Tom's views on that.
Yeah. Thank you, Chief Justice. Yeah, I agree with that. I mean, in relation to pre-trial procedures and so forth, actually the reason I called the paper the Allocation of Criminal Jurisdiction, again, is that, of course, this was all considered in great detail back in 2001, 2002, 2003, by a committee that was chaired by Mr. Justice Fennelly of the Supreme Court. I happened to be on it at the time, and this is one of the things that we discussed at considerable length and made a recommendation, that insofar as possible, matters other than perhaps relating to the admissibility of evidence, that generally speaking, all those preliminary issues should be decided before the jury is sworn in. There is the problem about an appeal, an interlocutory appeal. I think you have to take an approach to that, which is that you don't have an appeal at that point, because it could, obviously in law you can never say never, but I think the general policy should be against an appeal, that the trial goes ahead. After all, it's still part of the trial process, and there is a general principle that once a trial begins, it should continue. We have the famous statement by Chief Justice O'Donnell one time that a criminal trial in particular should have the unity and continuity of a play. Now he's talking about a real play that would be put on in the Abbey. If it was in the Gate or something like that, it mightn't have much unity or continuity, but that is the idea. It should be, the trial should run to the end. There is, of course, another uncomfortable issue that we have to address in this country. Neither of us have addressed it this evening. And that is that one of the things that is, of course, quite unique about Ireland, about the Irish legal system, is that judicial review proceedings are used so frequently before a criminal trial takes place at all to try to stop the criminal trial going ahead. Somebody who's trying to prevent a trial going ahead on the grounds of delay, pre-trial publicity or lost evidence will take a case by way of judicial review. Now, when I first started practicing back in the early 2000s, I was involved in an awful lot of those, ironically in relation to delay in sex cases, where people were saying, I shouldn't be prosecuted because it's far too long since the offences were committed. And of course, I say it's ironic because one of the things it did was it very often added years to the overall trial process itself, which was very difficult, certainly for the complainant involved. And so the question is, should we continue to have a system whereby those issues are decided in independent pre-trial judicial review proceedings, or should we take the approach of other countries where those matters are decided before trial by the trial court as a preliminary matter by what are often called abuse of process proceedings? Again, in other countries where that happens, they don't allow any appeal until the entire trial is over. And so, that's a kind of a precedent that we might go on.
Thank you.
Justice Clarke, you were saying about the fact that there's few justices per capita maybe in Europe and compared with other kind of countries, and the question is if more people were to have access to courts, we would have to fire more judges, and if legal fees were brought down of barristers and solicitors, and we'd have to actually hire lots and lots of judges, but by European standards, our judges get paid 3 times what German judges get paid, and twice what French judges get paid. So I was just wondering, there's a bit of a conflict of interest between the citizen's right to his day in court versus the payments that we give to our officials. Thank you.
Can I take one more?
Yeah, sure.
I'll take another question here. Yeah, thanks. Behind you, sorry.
Pádraig Brennan, I'm a solicitor here in Galway. I thought it might just maybe make an observation in relation to some of the points that the Chief Justice made in relation to procedures. As well, the first point is in relation to whether it is desirable that judges should have access to the pleadings and documents in a case before he or she hears the case. That is, of course, preferable. But the difficulty, I think, on a practical level is that whether it's a personal injuries or a non-jury case, a chancery case, that the judge is only assigned to the case on the day, so that there seems to be little point to a judge actually reading into a case and then simply not being assigned that case. The second one, on a practical level, again, is the Chief Justice's suggestion that there might be a preliminary registrar or equivalent dealing with routine motions on a Monday. Certainly at a certain court level, that happens in this jurisdiction day to day, where the circuit court registrar not only deals with consent cases, but he hears cases or applications on their merits, and very few of those actually go to the circuit court judge. So it doesn't seem to me to be any kind of a quantum leap for that to also take place, or something similar in the High Court. One last point, I suppose, is in relation to I'd like to hear maybe some observations on the availability of public law remedies to those who can avail of public law remedies. So in other words, that public bodies are amenable to judicial review, and for instance, public servants have access to judicial review. And I wonder if there's an inherent unfairness to those who are only confined to private law rights in private law contracts.
Thank you. And I'll just take one more question if there's... Carol?
Carol Coulter, and I wanted to raise a particular hobby horse of mine, which the Chief Justice is probably aware of, which is the lack of a family court in Ireland. Now, he raised, I think, a very important issue around the jurisdiction of the district court, and particularly in relation, say, to something I have recently been interested in, which is child protection law, some of which cases are extremely complex and extremely lengthy, lasting for many years, and which can also run into a problem where there might be two jurisdictions involved, where children from the same family can end up living in different parts or neighbouring parts of the country. I agree that jurisdiction is a huge problem there, and reform of the jurisdiction is one way of looking at that. But then an alternative way, perhaps, is to look at the whole treatment of family law, which is overwhelmingly still dealt with in the district court, some of the issues being very, very complex. So perhaps there is an alternative way of looking at that particular area of district court jurisdiction by specialisation in that area. There is a great need for specialisation, which the existing structure of the district court doesn't permit.
Thank you. Chief Justice.
I think that's probably enough questions for that. Obviously, there is potentially a tension between the cost of judges. I would make the point, though, that in many of the countries that you mentioned, such as Germany, the judges are allowed paid additional work. In at least half the countries of Europe, judges can do academic work, and in most senior German judges also hold a professorship, which is quite well paid as well. So I think what they end up getting in their pocket at the end is not that much different. And indeed, in some European countries, about a third from the last survey I saw, judges are allowed to do paid arbitration work outside the court system. So I think there is sometimes a bit of an apples and oranges when people are comparing salaries from one country to another. But I also think even if you allow for the difference in what the taxpayer pays the judge to do judging, the difference in the number of judges is so acute that the cost to the taxpayer is lower. For example, Germany has 22,000 judges. German population is about, 84 million, so it's maybe 18 times ours. That would suggest that on a pro capita basis, we should have 12 or 1,300 judges. We have 160. So even if you paid each of them 3 times, the total cost to the taxpayer is still going to be a third. And I think what that does, and it's not really today's point, but it is a point I've made on a number of occasions, what we actually do is transfer costs. We make the parties bear a much bigger part of the burden of running the case. If there's a criminal appeal before the Supreme Court and Tom is appearing in it, I expect him to produce all of the relevant legal authorities and present them to me. If I was a German judge doing the same job, I suspect, the equivalent of Tom would be able to make whatever case he wanted, but I would expect to have a research department who would do a lot of that basic work for me. Secondly, I agree that the sort of pre-reading in won't apply in every case, but I would like to see us moving towards a situation where it was possible in more areas to assign the judge at least a few days in advance. The reason in PIs, I think, is because so many settle, it's probably difficult to envisage a workable system, because if you haven't a clue which cases are going to go on, there's no point getting judges to read 5 of them in the hope that they will have picked one that actually needs a hearing. But another, judicial review settlement is virtually unknown. Very occasionally it happens, but 95% of them go on. So there's no reason in principle why you couldn't decide a few days in advance that Judge O'Malley is going to deal with that one and Judge Clarke this one. And you could work around the odd occasion where a case either takes longer than expected or shorter than expected. So as I try to emphasize, I'm not a one-size-fits-all person. I think we've often made mistakes in trying to make one-size-fit-all, but I think we could probably move more cases into the area where the judge knew about it in advance. And the very point Tom made, that half of your typical affidavit-driven public law case involves counsel referring the judge to the papers. The judge could probably read them a lot quicker in the quiet of their own room, think about it, and come in with some focused questions, the way appellate courts now work, rather than the opposite. Your point about the county registrar, I think, is well made. I think that's exactly the kind of system I'm suggesting, and I think the High Court could usefully move to having people like county registrars doing that important part of the work and freeing up judges to do other things. I suppose that the public law, private law dichotomy isn't so much a substantive law issue to some extent, but it's the procedural advantage of having available judicial review. Normally a contract of employment, for example, in the private sector will have implied into it much the same kind of terms as the public law rights, but it's perhaps not so easy to enforce. Maybe we need to think of it, are there more streamlined procedures for dealing with particular types of cases, like employment cases? I was the Chancery motion judge for 3 or 4 years in the High Court, and my impression was that High Court employment injunction litigation was firstly confined to kind of the upper end of the employment scale. It was people who are chief executives or senior executives. And most of it was about looking for an injunction so that if you got it, you were in a tactically better position for the inevitable negotiations for the severance package. Because everyone knows if you're that level in the job and things have broken down so much, you're going to have to go. But if you have an injunction, the price of you going may well be an awful lot larger. On the family court, my own view is that I'm not convinced of the benefit of separate courts, if by court you mean an entirely separate legal entity. But I don't think, Carol, that's what you meant. We call the thing the commercial court, but it's not the commercial court in any legal sense. It's a list of the High Court. I am all in favour of specialised lists. And I think you've put your finger on one of the points I was trying to make, that because outside the major cities, and really to a large extent outside Dublin, the district court, and to a not insignificant extent the circuit court, is confined to 1 or 2 judges, being the only judges for an area. It's very difficult to build up expertise because the judge has to deal with everything. For example, could we have regional courts where you had groups of judges practicing together, as it were, where at least for a period of years a judge could deal with all cases of a particular type, would acquire the expertise? I think there's a lot to be said for that kind of model that would remove jurisdictional issues like the one you mentioned, where one child is in one district and one child is in another. And also, speaking personally, from having been a judge of a court where you got to meet your colleagues all the time, I think at a personal level that's very beneficial. You bounce ideas off people. People tell you stories about what happened. You hear things. If you're sent to be the only judge for a whole area and you never meet any other judges except at conferences, you don't have the benefit of that. So I actually think even the art of judging would be improved. And while it's not for me to decide, I could see some merit in saying, why not divide the country into, say, 5 regions? I don't suggest that has necessarily been the right number. It need a lot of work to do it properly, and say, well, we'll have circuit judges and district judges within that region, and each judge can deal with everything in there. And you can, like you do in Dublin, say, well, we'll have a district judge who'll deal with all of the childcare cases and we'll have the expertise to deal with it. And you mightn't want someone to have to do that forever because they might go mad. But you might say, we'll do it for 2 years and then you might go and do something else. I think that would allow the build-up of much more expertise and will be good for everyone. And will probably even be good for the judges' heads, which is a good thing as well.
That's fine.
I think on that note, bearing in mind the well-being of our Chief Justice and our respondent, I'm afraid we have to bring the seminar to a close, and just on behalf of the Law School to sincerely thank the Chief Justice for taking the time, and to Tom, our colleague, for responding for what was really a wonderful lecture from both, and for your questions and comments. And I hope that we'll have many opportunities in the future to welcome back the Chief Justice again. Thank you.